Welcome everyone to our webinar on cracking the due diligence code, insider tips for buying a business. My name's Anthony. I am a practice leader here at LegalVision's corporate team. Before we begin, just a couple of housekeeping items. You'll receive a recording, a copy of the recording of this presentation and the slides in your email after the webinar. You can submit questions in the chat box and we'll try to answer them at the end. And please, if you could complete the feedback of a survey at the very end of the webinar, we would really greatly appreciate that. Also, all attendees today are eligible to receive a free consultation with us to discuss how LegalVision can assist with all your contracts and other legal needs. To request your free consultation, just provide us with your contact details in the survey that appears at the end of the webinar. So today we'll be discussing the following kind of items, just broadly going over what due diligence is about, how due diligence is conducted and what the process is involved within it, how due diligence and kind of links in with the term sheet, how it links in with ultimately the relevant sale agreements, and then we'll kind of do a little bit of a deep dive into specific due diligence areas that you should be conducting as a purchaser of a business on the relevant target company or target business. So to kind of set the scene and to start off, we'll just kind of go over what due diligence is about. The first thing to kind of note as a preliminary point is to delineate between in mergers and acquisitions transactions, business purchases and company purchases. So in a business purchase, you are acquiring all of the assets of that particular business, versus in a shared purchase or a company purchase where we are purchasing either all or a substantial amount of the shares in that company. And also, you might hear me throughout this presentation refer to due diligence as DD, because that's just the vernacular that we use in the industry. So what is due diligence? It's ultimately the process of verifying and investigating, and in essence conducting almost like a semi-audit on the potential business or company target. It involves doing, a thorough inspection of all of the business assets and physical assets, records, even meeting with starts and kind of really going through the history of the business. The whole purpose of due diligence is to make sure that you as a buyer know what you are buying and that you're making an informed decision before your purchase. And also kind of then will highlight key issues that might need to be dealt with within the relevant sales contract, or it might, I highlight issues that are so critical that potentially you might need to walk away from the deal and not conduct the purchase at all. It involves, investigations into things like who owns the assets of the business, what are the finances of the business looking like, is it able to be, to generate profit, is it embroiled in disputes or litigation, etc. And we'll kind of go in a moment some of the areas that you'd be looking into. In the next slide, we've got just kind of generally where due diligence sits within the sales transaction process, and generally how a transaction kind of runs in its entirety. So one of the first steps is there's usually some initial sharing of information between the seller and the buyer about the business or the company, and usually the seller will require the buyer to sign an NDA, a non-disclosure agreement, or a confidentiality agreement. From there, the parties will then kind of move into discussing broadly the commercial terms of the deal and sign either a term sheet or a heads of agreement, which is predominantly a non-binding document between the parties, and as I said, it will set out the high level terms of what the price paid, how that price will be paid, some of the key terms of the agreement that the parties are upfront willing to enter into. From the term sheet stage, then parties are conducting due diligence, or the buyer is conducting due diligence, and usually at the same time as due diligence is happening, or more towards the end of the due diligence process, the parties are undertaking the negotiation of the relevant purchase or sales agreement. And then obviously once that's negotiated and finalized, the parties proceed to sign the agreement, and then ultimately complete the transaction. So in the next slide, we kind of deal with two important areas: who's involved and what's best practice when it comes to due diligence. Who's involved depends on whether it's a company sale or a share sale, or an asset sale. But usually it's definitely your professional advisors, your lawyers, accountants, and other advisors. And then certainly directors, shareholders, senior managers in the business, and potentially some other key employees. In terms of what's best practice, some of that is dictated by the size of the deal. With smaller transactions, certainly we see, I guess, a lot less rigidity and a lot more formality on how due diligence is conducted. For larger transactions, what you usually see is the buyer sending to the seller a request for information, or kind of like a due diligence questionnaire, which obviously, as it kind of implies, asks a whole lot of questions about the seller and the business. There'll also be a data room. And again, for bigger transactions, that's usually done through a third-party online platform like Ansarata, which are incredibly useful and incredibly efficient way of organising all of the relevant bits and pieces and documents and records of the business. As parties are going through the request for information process, there might be some further additional questions that kind of arise out of that process. And again, everything is kind of kept within the data room, so that everything's kind of in one place. But I mean, as I said, in less kind of formal, smaller transactions, parties might decide to use something less formal, like Google Drive or Dropbox, or kind of some other similar location for the data to be stored. In the next slide, we've kind of just gone through broadly what are the areas that we would look to be conducting due diligence as a buyer, and they traverse quite a number of areas. So, if you're whether you're doing a company transaction or a business transaction, business asset transaction, looking into things like plant and equipment, for example, whether it's the state of it and whether there are any encumbrances, looking at all the material contracts with suppliers and clients, conducting public searches, so looking at the state of the relevant company on Companies House, and potentially conducting litigation searches, and potentially conducting searches on IP at the Intellectual Property Office's website as well. Looking into the company or the business's property leases or premises licenses, or subleases for that matter. Conducting, again, doing a full audit on all the intellectual property that a business either owns or potentially licenses as well. Looking into what type of insurance the business has had, or the company has historically had, what claims potentially they've had in the past. Employees, which we'll go into a little bit later. definitely a key area in understanding all the entitlements, etc. But we'll touch on that in a moment. And definitely, just generally, particularly within the context of a share purchase transaction, doing a full audit on the company's governance documents and looking at the health of of its registers and company's house and its registers, etc., which we'll also touch on in a moment. So one of the kind of, as I said, steps within the transaction process is usually parties entering into a term sheet or what's also known as a heads of agreement. Most of the time, most of the term sheet itself is non-binding, so it's not legally binding on either of the parties. It just sets out commercial terms. However, the parties can negotiate certain provisions to be binding. Now, as a buyer, one of the most important provisions that you can you should be trying to negotiate into your term sheet is an exclusivity period. What's an exclusivity period? Basically, we're saying that the seller or the target company won't go off and try and shop or sell the business or its assets or its shares to any other third party. And that gives you, as a buyer, obviously certainty in conducting your due diligence. Conducting due diligence can be a particularly expensive exercise when you consider that you're engaging lawyers and accountants usually to assist you in that process. So, you really kind of do want to make sure that there is a period of time that that you're the only one looking at that business and the only one that's going to be the potential buyer. And the term sheet can set that out. And sometimes we've certainly seen as market standard that the term sheet might also include a provision that says something along the lines of, if that exclusivity clause is breached by the seller, that then the seller needs to pay your costs in undertaking due diligence up to a certain amount, and usually that's in the form of a kind of like a capped indemnity. In the next slide, probably the most critical slide really in terms of where due diligence fits in is its link to the sales agreement. Now, the sales agreement will contain and gives you as a buyer a set of warranties from the seller, and usually indemnities, which are about the seller themselves, and also more importantly about the target business and the target company. So for example, there'll be a warranty from the seller that they own all of the shares in the company free of any charges or encumbrances. Or it might be a warranty that the target company hasn't been embroiled in any litigation within the last 3 years. Or a warranty, for example, that the business assets are in good working order, and that the seller has complied with all occupational health and safety laws. Now, if the seller breaches any of those, those warranties that are within the sales agreement, i.e. that they become untrue, then what would you as a buyer, what are your rights? You have a claim against the seller for damages that you might suffer as a result of that breach of warranty. And usually the sale agreement will also contain an indemnity given by the seller in your favor as a buyer for those breaches of warranties. And ultimately, what does that mean? That means that you as a buyer contractually can sue the seller for that breach of warranty as a contractual debt. So any loss and damages, etc., that you suffer, you can basically recover as a contractual debt, as opposed to having to go off to court and pursue a breach of contract claim and prove your damages through the courts. Now, a key kind of way that the seller tries to limit their liability for breaches of those warranties is to disclose against them. And basically that means that there'll be, in essence, a provision or a clause within the sales agreement that will say that the seller won't be liable for any breaches of warranty if the particular matter has been disclosed to you as a buyer, either within the relevant disclosure materials, so stuff that they disclose in the data room, or potentially that to the extent that it's been set out within a specific disclosure letter that is attached, either attached to the sale agreement or given to you as a buyer in conjunction, with the sale agreement, usually at the time that you sign the sale agreement. So ultimately, from your perspective, that's really important to be conducting a thorough assessment of all the materials in the disclosure materials and all what is set out within the disclosure letter, and making sure that whatever it is in the disclosure letter is very clear and unambiguous, because ultimately that can limit the liability of the seller for any of those breaches of warranties. Now, I guess another kind of important aspect of due diligence for you as a buyer is also then potentially highlighting particular issues that will become what are known as condition precedents of the agreement. Now, what is a condition precedent? Basically, it's the occurrence of some event that needs to happen. Otherwise, you can, or the other party usually can simply terminate the agreement and walk away without really anybody suffering any loss. So, for example, it could be that there is, let's say, a particular government license that is required in order for you to operate this particular business. You need that government license to either be assigned over to you as the buyer or a new one entered into by you. And so you make it a condition precedent of the agreement that if that doesn't occur, then by a certain date, ultimately you get to terminate and walk away. And to the extent that you've paid any deposit, for example, as a buyer, then that deposit would be reimbursed. Or alternatively, it might highlight again certain issues that maybe they're not condition precedents, but there's certainly things that need to happen at completion as a completion obligation on the seller. So again, it could be something like key contracts with a supplier that needs to be signed over or novated to you as a buyer, because they're critical to the ongoing operation of the business. Due diligence can also highlight, again, and I kind of mentioned this before, highlight issues that are so critical that potentially you walk away from the deal, or they are highlighting issues that are particularly risky, and maybe that means that you are kind of going back to the drawing board and renegotiating the ultimate price that you're paying for that particular business. Or alternatively, it could be something that requires a very specific indemnity in the agreement to try and cover you. So let's say, for example, you find out that the target company is involved or has been involved in a nasty piece of litigation with a particular customer. Things are looking a little bit dicey. It could be the case that ultimately the company is going to have to fork out quite a lot of money in paying damages to that client and their legal costs. So potentially they're including within the sales agreement a very specific indemnity on that particular issue, so that in the event that the company does need to pay out those damages, that the seller is ultimately covering that cost. Just as an example. Now we'll kind of go into very quickly a bit of a deep dive into certain areas of due diligence and the type of things that you're kind of looking for in each of those areas. So the first is arguably one of the most important is the financial reports or finances of the particular business or company, and tax. So that a lot of this will also be driven by you sitting down with your accountant and looking through these numbers, and it's all about verifying that all of the numbers that have been presented to you stack up. Is that particular business actually profitable and performing well? Are any of the forecasts that have been given to you, are they legitimate? Are there hidden liabilities that you should be worried about? if the price has been dictated by EBITDA, which is earnings before interest, tax, and amortization, do those numbers stack up? Does it justify the purchase price and the multiple that you are ultimately paying? And certainly for situations where you're buying all of the shares in the company, it's really important to be doing a bit of an assessment on the tax history of that particular. Are all their lodgements and tax returns up to date? Are there any outstanding tax liabilities that you need to be kind of worried about? Another kind of key area definitely is employees and contractors, and I think probably the first point I would say on this is, and I'm sure many of you already kind of know, that where there is a transfer of a lease of a business, so when we're specifically talking about a business purchase transaction, where there is a transfer of the business, there is the TUPE or TUPE regulations, which basically require any of the existing employees within the business to be transferred over to the purchaser. So, and as part of that transfer, there any historical claims kind of potentially come over to you. Their terms and conditions of employment come over to you. Their accrued entitlements come over to you as a buyer. So it's very, very much the case that you need to do a really thorough assessment of understanding what those obligations, what those potential historical claims are, understanding what the accrued entitlements are of employees, and understanding what their current terms of contract and current terms of engagement are. I think also part of the DD for employees is I guess understanding whether any they're unionized, depending on the industry that you're in. Are there collective agreements in place? Are there any current disputes in place? And that potentially also then influences again specific indemnities in the sale agreement or potential price adjustments. So it could be the case that you negotiate an adjustment down to the ultimate purchase price that you're paying by taking into account all the accrued employment entitlements that you're ultimately going to pay, and that that ultimately you'll be liable for. So you're reducing the purchase price down. There could be employee option schemes in place. If you're doing a company share purchase transaction, if you find that there is an option scheme in place, then that's probably something that you want to make sure that is being wound up before you take over the company, and those options are simply either lapsed or employees are being paid out and those options cancelled, etc. I think another important point is then, looking at what contractors are in place, or workers or self-employed people that the company has potentially engaged, and indeed questioning whether there's any sham contracting in place. So, are those persons that are allegedly self-employed people that the company is engaging, are they actually self-employed, or is it the case that the engagement is such that really they're potentially deemed our employees, in which case we're liable for them, and then again you're potentially looking at including additional warranties and additional indemnities within the sale agreement to cover you as a buyer. In the next slide, we kind of go into the specific issue of corporate governance, which is really only relevant where you are undertaking a share purchase transaction, and it's about just kind of doing a health check on the company. Is their company register all up to date? And in accordance with the Companies Act, has all the resolutions and company books been kept in order? What do those resolutions say? Has Companies House been kept up to date in terms of showing the current people who are directors and secretaries and all the relevant kind of transactions that have occurred within the company? has their, what's the constituent documents looking like? So there, what are we talking about? We're talking about the articles of association, and any shareholders agreement. What are they? What are those provisions looking like? Is there anything there that we need to deal with, particularly as that relates to the transaction? And potentially, is it the case that we also need to be thinking about adopting a brand new set of articles of association following completion of the transaction? Are there any, I think what big question is, are there any other forms of securities that the company has issued? So are there convertible notes or other options, or shareholder loans that are convertible into shares? What exists out there? Do those arrangements need to be kind of unwound or dealt with prior to completion, which is usually the case? And then lastly, are there kind of, again, any government or other type of licenses that the company needs to hold, or authorizations that they need to hold? And are they assignable? Do they need to be transferred over? Do third-party consents need to be obtained as a result of the completion of the transaction or the underlying change of control? And then you're also kind of probably looking at it from the perspective of, have there been compliance with those licenses historically, or are there any potential current breaches in place? Sorry, current breaches for those licenses. Another key area in due diligence is assessing all the companies or businesses material agreements. And so what are those material agreements that we're looking at? It's agreements with customers, particularly with key customers, any supply agreements. You can imagine if you're a manufacturing business, there might be key ingredient suppliers that you need, that are pivotal to your business. Or if you're a distribution business, then the distribution agreements that you've got in place with certain overseas brands. What property licenses, property agreements are in place, potential profit share arrangements, IP licenses, etc. Really, it's the process is about understanding what agreements are in place, understanding what provisions you need to deal with, whether you're an asset or a share transaction. So if it's an asset transaction or business transaction, then it's about understanding, are those contracts able to be assigned? So do they have assignment provisions, and then do the parties need to enter into a deed of assignment or deed of novation? If it's a share transaction, do any of those contracts have change of control provisions, which basically mean that you would need to obtain the other party's consent before the change of control happens, in order for that contract to basically continue or avoid the ability of termination. I think you're also looking at each of those contracts in the context of, what are the termination rights? Are there any unusual or particularly onerous or non-market standard terms within those contracts that you'll ultimately have to kind of continue on with as the incoming purchaser of the business? And again, we've mentioned it before, the link to all of this is to the sales agreement, is potentially including conditions, precedents, or completion obligations around assignment or obtaining third-party consents, or potentially having to get into completely new arrangements with particular parties. So, you can imagine if you were a business where a government client was made up 30% of your sales, then it's probably the case you want to make sure that it's a condition precedent, or at least a completion obligation in the contract, that government client potentially enters into a new contract with you, or assigns that contract over to you as the buyer. And then kind of in our final slide, the final area, key area in undertaking due diligence is obviously intellectual property. Now, for some businesses, intellectual property is the most valuable asset that they have. And that could be in the form either of trademarks, patents, business name, copyright, designs, registered designs, etc. And a lot of the assessment around IP is trying to understand what IP the business actually owns. Is it registered, or should it be registered before completion? If it's IP that is owned by another party and so critical to the business, then what licenses are in place, and what are those terms? What are the terms of those licenses? Will they be able to continue on when you're overtaken the business? And then also taking into account, well, how does your IP sit in terms of infringement of third-party rights? So, are there other people out there that potentially, have made a claim against the business for IP infringement or trademark infringement, for example, or passing off, for example, or is there potentially the other way around? Are there actual people out there that are using a brand similar to yours, and action should have been taken because they're infringing your IP? It could be that you're an app, you've developed a particular piece of software or a SaaS provider, and you're relying on open source code. Again, doing an assessment of, well, what is that open source code? What are the terms and conditions around using that open source code? And that's, I think, concludes basically the main part of our webinar, everyone. You will find that we have a publication that's available. On the next slide, you can download our due diligence guide for purchasing a UK business, either in the handout panel or by simply scanning the QR code. We will also be answering some of your questions shortly, so by all means, please submit them now if you do have any questions for me. While you do submit them, I'll just take a minute to tell you a little bit about our LegalVision and our membership. LegalVision membership is a cost-effective alternative to have all your business as usual legal needs covered. For a fixed monthly fee, you not only receive cost certainty, but all-inclusive benefits such as unlimited contract document review, which would include reviewing your commercial contracts, unlimited legal consultations, which means you can basically book meetings with a lawyer at any time to discuss any of your commercial contracts or other kind of business as usual legal needs. You can talk to our lawyers about franchising, employment, corporate needs, depending on your particular business. And your membership includes unlimited trademark registrations for all, one very reasonable monthly fee, with options to purchase extra credit towards complex matters and ongoing disputes, which are charged on an hourly basis. So very affordable, very efficient way, and very different way of receiving legal services. We'll now answer some of your questions, which I think there were a couple that had been submitted prior to the call. One was around, do minority shareholders have a right to receive information when being bought out? I think a lot of the time that'll be dependent upon what's included within the specific provisions of a company's articles of association or shareholders agreement. Certainly, if the buyout was potentially under a drag along provision in the shareholders agreement or the articles of association, there might be provisions in there that at least require the majority shareholders to kind of set out in a notice who the buyer is, what are the terms of the purchase, when the purchase or the acquisition will be done. So I think to that extent there would be rights to receive information, but there could very well be other provisions in the articles or the shareholders agreement which give just shareholders generally rights to request information regarding the business. I think the other point to note is that generally there are some very limited rights under the Companies Act for shareholders in terms of requesting access to certain company records. I think one potential overlap area might be their ability to access board resolutions, so I guess, to the extent that there was any information in the board resolutions around a potential acquisition, then I guess that could be captured. But I would dare say that it's more sitting within the Articles of Association and shareholders agreement. We had another query around how intangible assets are valued. To be fair, I probably wouldn't be able in a position to answer that particular question. It's probably more of a question for an accountant to deal with. But certainly, if you're on the call or you're on the webinar and you wanted a referral, where LegalVision has a host of referral partners, and we'd certainly be able to refer you to one of our very esteemed accountants or business valuers to assist. I don't think there are any other questions at the moment, so I think we might leave it there. Thank you so much, everyone, for your time today. Again, after the webinar ends, there'll be a survey that'll pop up. We would really appreciate you completing it. It only takes 30 seconds. And please include your contact details to receive a complimentary legal consultation to discuss how LegalVision can assist you in your business. Thanks so much for joining us.